Okay, I'm ready to go back on the record with that other matter.
Okay, Judge. Recalling case number 2356221, the people of the state of Michigan versus Charles Sledge. Defendant is charged with count 1, motor vehicle unlawful driving away, count 2, stolen property, receiving and concealing motor vehicle, habitual offender, second notice.
Good morning, Judge Alex Ryan, on behalf of the people, P number P86590.
And Jihad Kaddaf, P82492, on behalf of the defendant. Your Honor, we left off with the court requesting that I make an attempt to contact the Novi District Court. I did. After some time, I finally got a hold of the supervisor who was willing to release the information to me based on our conversation. Mr. Sledge was taken into custody by the Novi District Court after a hearing that had taken place. I won't place the reasons why on the record, but he was taken into custody. That's why he's not answering his phone. And I did confirm he is in Oakland County custody now.
All right, thank you. People wish to be heard.
We would just like to get an exam date.
All right, so at this point in time, I believe the defendant now has to be writted out of Oakland County. Is it your understanding that the defendant is going to be in custody, Oakland County, for a period of time?
Your Honor, I was not able to obtain information. They would not release any details to me, but they did tell me that the matter that he had been taken into custody for is a rather severe matter. So therefore, he may be in custody for quite some time. I'm unsure until I do a little more investigation. But given in light of the facts, I believe we can get Mr. Sledge written out within a couple of weeks to appear here in court.
We need 2 weeks of advance notice. So Madam Clerk, can we have a 2-week date out to reschedule this exam?
Sure, Judge. May 4th at 9:30.
Works for the defense, Your Honor.
All right, thank you. All right, if there's no objection, the court will continue the bond.
Thank you, Your Honor.
Thank you, Judge.
All right, thank you.
Oh, yeah. Good idea. All right, so there's that one. So we got. Oh, okay. Yeah, 3 more.
No, they won't. Oh, yeah.
Good morning, Judge. Good morning, Your Honor.
Can I help you? Good afternoon. Can I help you?
Yes, hi.
Yes, can I help you?
Yeah, I have a court session scheduled.
For
I can give
today?
you, yes, I can give you the numbers. That's gonna help
What
you
type of
look it
case
up.
is it? What type of
It's,
case is it?
Court is now back in session.
Hello?
yeah, I'm sorry. I'm having some connection issue. Can you repeat that?
What type of case is it?
Yeah, just 1 second. Let me look at my paper.
All right.
Okay, I'm gonna put you on mute right
Tell
now
her to call
because,
the courtroom, please, Kitty, and call the next case.
okay, can you just call the courtroom? I'll put the number in chat, okay? Parties ready on Kevin Marks? Calling case number 2356169, the people of the state of Michigan versus Kevin Marks. Defendant is charged with count 1, larceny in a building. Count 2, assault or assault and battery. Count 3, larceny less than $200, habitual offender fourth notice. This matter is scheduled for examination. Defendant has failed to appear.
Good morning, Judge. Alex Warner on behalf of the people, P number P86590.
Good afternoon, Your Honor. Neighborhood Defender Service by Cheryl Quick, key 83973. We have Kevin Marks. Mr. Marks is not present. I have no representations. I've not had any contact with Mr. Marks. No phone number was provided.
All right, people wish to be heard.
The people, necessary witness has failed to appear and motion for capias.
You mean, okay, so you're not ready to proceed.
Right.
Okay, thank you. All right, the defendant has failed to appear for the preliminary examination. The court will issue a capias. The bond is, personal bond is revoked. New bond will be set at $5,000 cash for sure. All right, what's next?
Thank you.
Calling case number 2261109, the people of the state of Michigan versus Jalen Gunter. Defendant is charged with count 1, robbery armed. Count 2, assault with intent to do great bodily harm, less than murder or by strangulation. Count 3, robbery unarmed. Count 4, unlawful imprisonment. This matter is scheduled for examination.
Good afternoon, Your Honor. Ed Bookbring on behalf of the people, P86266.
And good afternoon, Your Honor. Rita White on behalf of Mr. Jalen Gunter, who is present. Please state your name, Mr. Gunter.
All right, thank you. You may have a seat, sir. Are the people ready to proceed?
Yes, we are, Your Honor. Before we do, just one preliminary note. I have spoken to Ms. White.
Imagine Robbie.
Sorry, you need to close out the people that are in the courtroom. They have to be in the waiting room at this point in time that we're on record.
Okay, yes. Yeah.
Counsel.
Thank you, Your Honor. The people I've spoken to, Ms. White, if the proof show the people would intend to add 2 charges today, The first one being felonious assault contrary to MCL 750.82.
Shut up.
I'm sorry, MCL 75, say it again, please.
You know what? You have to enable your waiting room. Are you the host?
Yeah, well, I told you.
No, let me show you. what you have to do. I will not be able to, I know you won't be able to.
They love you.
No, and you have to enable your waiting room. You have to enable your waiting room so that when people come back in,
No, just
that
say
they
it
can't
again.
come in. I'm gonna show you how to do that. All right, go over to security. Enable waiting room, so we'll check by it. Now, no one can come in.
Oh. Thank you.
You're welcome. All right, make my first witness.
I wasn't done with preliminary matters, may I just, Your Honor?
Yeah.
The people, if the proof shows the people intend to add felonious assault contrary to MCL 750.82, and the second count of torture contrary to MCL 750.85.
Okay, you can write that down for the court clerk in the event that your motion is granted. Count for your first witness.
Thank you, Your Honor. At this time, people would call Parker Tate.
How many witnesses do you have?
Just one, Judge.
Your Virginia, everything. Sir.
Sir, your name, please.
Parker Tate.
I'm sorry.
Parker Tate. J-A-R-K-E-R-K-E.
Oh, thank you.
That's what it is.
All right, raise your right hand before you sit down. Face me. And do you affirm the testimony you give to this court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you may be seated.
Have may the witness hold the microphone.
Yeah, you're gonna have, just gonna have you hold it.
Oh,
Just
okay.
hold it in your lap and talk right into it, because everybody has to hear you, but especially the court reporter, because she takes down everything that you are saying and everything that we are saying.
May I proceed, Judge?
Yes.
Thank you, Judge. Mr. Tate, can you please state your name for the record?
Parker Tate.
I want to direct your attention right back to November 26th of 2022. Were you at the location of 11405 Lansdowne Street?
Yes, I was.
Is that in the city of Detroit, county of Wayne?
Yes.
And what is at that location?
It was a trap house.
Okay, and so, around what time did you arrive at this house?
I'd say 8 o'clock around there.
8 o'clock in the morning or in the afternoon?
Afternoon.
So what did you do when you got to that house?
Well, I walked in and then I walked
Did you say
upstairs.
8 o'clock?
You
Yes.
said 8 o'clock, I believe. Your Honor.
But 8 o'clock's not in the afternoon. 8 o'clock is either morning or night. So, I mean, I'm
Oh.
sorry, I mean, he said afternoon. That's why I'm wondering, is it 8
Yes.
o'clock?
8 o'clock after
8 o'clock PM,
PM.
evening.
Yes, Judge.
Okay, so not afternoon. Oh, thank you.
Okay, so 8 o'clock in the evening, you arrive at this house. So what do you do?
I walked upstairs and we rolled up
Okay,
to the
so,
smoke.
so let's stop right there. So I'm assuming you walk in through a door, correct?
Yes, I do.
Did
I'm
anybody,
walking through the side door.
you walk in through the side door?
Yes, sir.
Does anybody meet you at?
He does,
Okay, so,
Mr. Jalen.
okay, so, you see Jalen in the
Yes, I
photo
do.
here today? And could you please point him out and identify my article clothing?
Right there, and the green jumpsuit.
Okay, Your Honor, may the record reflect that the witness identified the defendant, Mr. Hunter.
So noted.
Okay, so he meets you at the door, and so what do you do when he meets you at the door?
I dab him up and say what's up, and then we go into the house. I turn around, lock the side door behind me, and go upstairs.
Okay, so when you get upstairs, is Mr. Gunter with you?
Yes, he is.
Is anybody else there?
Manara, my ex-girlfriend.
So the three of you are there, what do you do?
We roll up, we start joking around, talking, and we smoke.
Okay, and what happens next?
He left to go get a friend who he said had more weed, and they were gonna go grab some grass or woods.
So let me stop you right there. So you said he's
Yes.
he, Mr. Gunter?
Yes, sir.
Okay, so does he end up leaving?
Yes, he does.
Does he end up returning to the home?
Yes, he does.
What happens when he returns to?
He brings a friend, but no weed, no blunts.
Do you recognize that person that he came with?
No, I do not.
So what happens next?
He leaves again like 5 minutes later and goes and picks up another friend and comes back.
Do you recognize this third individual?
No,
Both of these individuals, these friends of his, are they both males or are they females?
males.
So what happens when this third person now enters the room?
They say that he has a problem with me and that they say he wants to go 30.
Hearsay.
Well, who says? Who
Um,
says, the defendant or someone else?
Jalen said that he had a problem with me.
All right,
the-
and is
the
Jalen the
most recent
defendant?
guy.
Then it's not hearsay. Go
Okay.
ahead.
What did you say?
No, I'm making a record
Oh.
of the objection, so
I'm
you
sorry.
can continue what you were saying about Jalen, but you can't tell us what somebody else says.
Okay.
All right, so Jalen said, what?
He said that he called him his nephew and that he had a problem with me and that he wanted to go 30.
Okay, so let me stop you right there. Briefly, Your Honor, just one moment. So you said something about going for 30, is that
Yes.
correct? What does that mean, going for 30?
Basically fighting for 30 seconds.
So who told you to go to fight for 30 seconds?
Jalen did.
Specifically to fight who?
His nephew or the third guy that they brought.
Did you want to fight him?
No, I did not.
Did you have a choice in the matter?
No, I did not. They told me that if I didn't fight him, they were going to jump me.
What do you mean by jump you?
All three of them were going to fight me at the same time, so it would be 3-on-1.
So what do you do then after this was told to you?
I get up and I go ahead and throw a couple punches at them, and then they jump me.
They being who?
The three guys.
Including Mr. Gunter?
Yes, sir.
So what's going on when they jump you? What happens?
I'm covering my face to make sure that I don't get hit in the face. I'm looking around, I swing a couple times, and they threw me up against the wall, and then they started hitting me, and then they threw me up against the bed, and they started hitting me and kicking me,
So
and
let's-
then they started hitting me with kitchen utensils.
Okay, so let's stop right there. So you said they're hitting you. How are they hitting you?
Their fists, they're kicking me, and with objects laying around the room.
And where are you being kicked, punched, and hit with objects? Where in your
I
body?
was kicked in the side a couple times. I was getting punched in the back of the head, in the face, in the chest, arms.
And you said you were thrown onto the wall.
Yes, I was.
So what happens when you were thrown onto the wall?
I hit my head against the wall and I stumbled a little bit, get back up and covered my head again.
And then next thing you said was that they threw you on the bed. What happened when you were thrown on the bed?
They pushed me on the bed. I sat down on the bed and covered my head like so.
Okay, so for the record, the witness has tucked his head into his lap and covered his head with both arms.
All right, so now,
Thank you. So you said they hit you with utensils, is that what I heard?
Yeah,
What kind of utensils?
spatula, wooden spoon. I believe it was a wire brush too, because there was these like bunch of red dots on my forearms from where I was defending myself.
So while this is happening, do you hear Mr. Gunter saying anything to you? Not anything from those other two individuals, specifically Mr. Gunter, is he saying anything to you?
Not really. I hear a lot of grunting.
Okay. So what happens then after or during this time that you're on the bed? What happens next?
Next, they poured barbecue sauce, hair bleach, and rice on my head, and then they cut my hair.
Okay, so let's break that down. So is this happening while you're on the bed?
Yes.
And where are Mr. Gunter and these two individuals with him?
One of them is sitting behind me cutting my hair, or no, they're sitting in front of me cutting my hair while I have my head down. And all three of them are in front of me. None of them are on the side of me or behind me.
While this was happening, did you consent to any of it?
No, I did not.
Did you attempt to leave at all?
I tried, but they were blocking the stairwell.
Who was blocking the stairwell?
The two friends.
So you said that they poured barbecue sauce, bleach, and rice on you, is that correct?
Yes, sir.
How did you feel when that was happening?
Demoralized.
When they were cutting your hair, how were they cutting your hair?
With a pair of scissors, and they basically just scalped me.
How was your hair before it was cut?
It was a little bit past my shoulders.
And so you said they cut it with scissors?
Yes, sir.
How short was it cut?
That much was gone. Or like that much was left.
So an inch or two?
Yeah, not even.
How did you feel when they cut your hair?
Like I wasn't myself anymore. That they stripped me from my identity.
So what happened next?
They made me down a whole bottle of NyQuil.
What do you mean they made you down? What does that mean?
They said that they were going to continue beating me if I did not drink a whole bottle of NyQuil.
So did you drink that? bottle
Yes,
of
I
NyQuil?
did.
Did you want to drink that night?
No, I did not.
What happened next?
They made me clean up the mess. And they made me strip down to my clothes, all the way down to my underwear, no shoes. I was just in my socks, my underwear. And then they made me walk downstairs, say goodbye to her, and they made me leave.
So let's break that down. You said they make you clean up the mess.
Mhm.
What mess are you cleaning up?
The rice, the barbecue sauce, the air bleach, and basically the rest of the room.
What is Mr. Gunter and his two associates, what are they doing while you're cleaning that mess?
Mr. Gunter was sitting in a chair holding a sledgehammer, and his other two were blocking the stairwell.
Did Mr. Gunter say anything to you during that time?
When I got done cleaning up, he told me that there's not gonna be any police situations over here, right? Right here. And he said, if there are, I'm gonna start with your family and then I'm gonna end with you.
So after you clean the mess, Mr. Gunter says that to you. You said you went downstairs to say goodbye to somebody. Who did you go downstairs to say goodbye to?
Manara.
That the female that was in the room earlier? And at this time, did you put your clothes back on?
No, I still have them on.
So you had no clothes on?
No, I mean, besides my underwear.
So what did you do next?
They put me up the side door and I started to run home.
So when you initially went to the home, did you have anything, other than clothing, did you have anything with you?
My home?
No, before you came to this address that we're talking about right now, where all these things happen, did you have anything with you when you arrived?
Yes, I had my phone, my speaker, a pair of jeans, my shoes, a jacket, and a shirt.
And when you left, what items were you permitted to take with you?
My socks and my underwear.
You said you had to run home?
Yeah,
How far away did you live from this address that we just spoke about?
about a mile.
What was the weather like?
It was cold, very cold.
So what happened when you arrived at your house?
My dad said, "What the hell happened to you?" And I said, "I
Objection,
don't want to talk
hearsay.
about it."
Sustained.
So without telling me what your father said, let me just rephrase the question. Did you ever report this incident to the police?
Not originally. I lied about the statement because I was scared for my life.
So who did you lie? So you said you lied about the statement. Who did you lie to about the statement?
The police officers who came to accept the call that my dad put in.
Okay, so you spoke with the police, so the police arrived at your house, you spoke with
Yes,
them?
yes,
And so why did you lie to the police about what happened?
because I was scared.
I want to go back to when you were physically hit. Did you suffer any injuries as a result of what happened?
Bruising, a lost tooth, and my pride.
What, you said you lost a tooth. Which tooth did you lose?
My left one, my left front.
Right in the front there?
Yeah.
In the events that, so after all this happens, and you said you made a statement to the police, did anything else happen after all of this?
Could you explain a little bit more?
Did you seek any treatment, other than for your physical injuries?
Yes, I had to go to the mental institution and I had to get medication for PTSD, sleep, and, depression, antipsychotics.
Were you taking any of those prior to the incident?
No, I was not.
Thank you.
Now, you said you lived about a mile from the address that we were speaking of. Do you still live in that area?
No.
Did you move out of that area then?
Yeah,
When did you move out of that area?
around Christmas,
Around Christmas?
Yeah.
So
a couple days before Christmas.
So less than a month after then?
Yeah.
One moment. Were you planning on moving homes or not?
Yes, I'm gonna object to the relevance.
What is the relevancy,
This,
counsel?
this all goes to specifically the added count of torture, Your Honor, because there's an element of the torture, mental pain is an element. I'm trying to show that, Mr. Parker suffered severe mental pain as a result of what happened to him.
By not being able to go back to his home or having to move?
Yes, by being forced out of where he lived as a result of what happened.
Counsel, I think you might be interpreting the statute differently than what I am. So I'm going to sustain the objection.
Okay. Thank you.
Thank you.
No further questions. Thank you.
All right, Francis.
Thank you. At the time of the alleged offense, were you 17 years old?
Yes, I still am.
And were you in school?
Yes, I am.
And can you read, write, and
Yes, I
speak
can.
English language as you did today?
Yes.
Okay, so you indicated, you identified Mr. Gunter. Had you known him before?
Yes, we played basketball a couple times. I bought weed from him.
Okay, so you had testified that you had gone to a trap house,
Yes, ma'am.
and that was a land down?
Yes.
What is a trap house?
I guess it's a house where I didn't really know what it was when I first went there, but after the fact, I figured out what it was, and it was basically a crack house.
Now, with regards to, you had testified that you had gone to meet with a lady named Manara,
Yes, ma'am.
and what is your relationship to Manara?
She was my girlfriend at the time.
Okay, and so you went to the home and Manara had called you to the home,
Yes, ma'am.
okay, and you met with Manara.
Mhm.
Okay, and you also indicated that you had engaged in smoking, you wanted to smoke weed, correct?
Yes.
How much weed did you smoke that time, that evening?
A gram and a half.
So would you say it rose to the level of you being high?
I wasn't very high. I have a high tolerance. I do smoke a lot, yes, but I was normal.
Okay, however, you indicated you weren't very high, so you were at some point a point that you were under the influence of the marijuana,
Yes.
correct? Okay, and now you had indicated that you had first made a statement and then you lied, correct, on that
Yes, ma'am.
statement? Because you were scared of what?
I was scared that he was going to come after me and my family.
Who?
Jalen Gunter.
By making a statement to the police?
Yeah, I made a false report to the police because of that.
Okay, and did the police advise you before or during the time that you made the statement that this statement would be provided to Jalen Gunter?
No.
Okay, so so it's fair to say that on around November 26th is when you made the statement to the police?
Yes, ma'am.
Okay. All right, so you had it's fair to say that on the first statement that you made, you had told the police officers, did you meet with the police officers in the precinct or in your
No,
house?
they came to my house.
Okay, and who were you with when you made these statements on the 26th?
My dad, my stepmom, and my sister.
Okay, and had you spoken to your dad, stepmom, mom, and sister prior to the police arriving to your home?
Not really. I mean, as soon as I walked into the house, they called the police.
Okay, and did you tell, your relatives what had happened before the police arrived?
Nope.
Okay, so it's fair to say that on the 26th, you reported to the police that you were picked up by a large number of males, correct?
Yes,
And you were assaulted, in which you were drove around in a van, correct?
yes,
And you continued to be assaulted while these individuals were going through your pockets and taking your cell phone and speaker, correct?
yes, ma'am.
And then they took you to an abandoned house,
Yes, ma'am.
okay, and then forced you to drink a bottle of NyQuil,
Yes, ma'am.
poured bleach,
Yes, ma'am.
barbecue on you,
Yes, ma'am.
and cut your hair with scissors.
Mhm.
Okay, and then they put you in the back of the van and then dropped you back off where they picked you up?
Yeah, that's what I said.
Okay, so that was November 26th.
Yes, ma'am.
Okay, and how much of your hair was cut? Was it cut, where was the area that was cut?
All right, my hair used to be all the way down to my shoulders,
Okay.
and it was all gone,
So you went completely bald?
almost. Like, I'd say I had maybe a half inch of hair left.
Okay, can you show like from your hair this much from your front forehead or
That
near the
much.
back of your head? This hair was still here?
Like that much hair was left.
Okay. One moment. So you had no hair like in the back, all the way in the back?
Oh, I had hair there, but it was very, very short.
Okay, so what I'm gonna do is. Okay, so what I'm going to present to you is defense proposed exhibit 1.
No, I just indicated.
Okay, do you recall being photographed?
Yeah, my dad told me when I was, oh yeah, I do. This was when the police came to my house. I also got photographed again when I was in the hospital.
Okay, so what I'm going to show you is this picture. Does this picture, do you recognize the picture?
Yes, I do. My hair was that short before I went over there.
Or you went over where?
Over to the house.
Okay. And who took this photo?
I believe it was a police officer.
Okay. And now, in terms of, you indicated that scissors were used to cut your hair?
Yes, ma'am.
To cut it all the way down?
Yes.
Okay. Your Honor, I would just ask that defense proposed exhibit 1 be admitted.
All right, any objection?
No objection, Your Honor, thank you.
You're
Okay,
gonna publish it, or what are you gonna do? Because I don't have a picture itself.
yes, I did. It's on my phone.
Okay, you can come show it to me so that at least I can see it. Please hold it up. All right, thank you.
Okay, so on the 26th, when you spoke with the police officer, you indicated that you then made a second statement, correct?
Yes, ma'am.
And that was what you are indicating was the correct statement?
Yes, ma'am.
Okay, so from the 26th, it's fair to say that that statement was made on or about December 6th of 2022, correct?
Yeah, a couple weeks after my first statement.
Okay, and did you speak with the officers or did your parents encourage you to move forward to change your story?
No, I decided to tell the truth. And I went and spoke to the detective.
Did you go directly yourself down to the precinct?
No, my dad drove me.
Okay. And now in terms of your father, it indicates that did your father also speak with the police? Were you aware of?
Possibly, a little bit.
Okay. So again, on the December 6th, it's fair to say when you were made the statement, did you write out your answers independently?
Yes, I did.
Okay, and you recall signing the statement when you finished providing your statement?
Yes, I did.
Okay, and let's see. And prior to providing this written statement, before writing it in, did you speak to the officers about any additional information, or did you just sit straight down?
No, I talked to the detective about additional information.
And what did you provide him before you made the statement?
All the details that happened before I wrote the statement.
Okay, so it would be fair to say that you provided the officer a summary or what you
Yes,
pretty much wrote down under the four corners of the statement you
yes,
made?
ma'am.
Okay, so what I'm going to present to you.
What was that last name? What case was it on?
Yeah.
Last wave?
Yeah, I just signed one that I did, I think, when I was upstairs.
Very much so, this is all stated. Okay, so what I am going to present to you is a document. If you could just take a hold of this and identify what this document is.
This is a statement I wrote.
Okay, and if you can look at the last page 2 of 2, does that have your signature?
Yes, it does.
And do you see your handwriting in the statement?
Yes, I do.
Okay, so you had testified, to this court that, you had gone to the house, to trap house, correct?
Yes, ma'am.
Okay, and upon reviewing this statement, it's fair to say that there's no mention of a trap house. We said from the fourth question, what happened on November 26th? The third line, you indicated, she said the trap on Lansdowne, correct?
Yes,
And that was referring to the trap?
yes.
Okay. Now, with regards to your testimony in terms of how this transpired, isn't it true that you were dating Renata, correct?
Yes, I was.
And it's fair to say that you were also in your statement indicated that Mr. Gunter was the father of Renata's daughter,
Yes.
child, correct?
Yes.
Okay, however, you didn't mention that on the record today.
I'm sorry. I thought that it was tedious.
I'm sorry, you thought that it was what?
Tedious.
Oh.
Okay, and you indicated that you arrived at 8 p.m., correct?
Yes, ma'am.
It was clarified it was in the evening, it was dark. Okay, and you also with your testimony today, you indicated that you walked upstairs and you rolled up a blunt.
Yes, ma'am.
Okay, however, reviewing your statement, it's fair to say that there was no indication of that you wrote that in your statement, correct? That you walked upstairs and rolled a blunt.
Right here on the 6th line, it says, in the side door, I went in upstairs, we smoked a blunt.
On what page?
It's the first one, 6th line.
And it's also fair to say that you also, if you can review your statement, that you didn't indicate in your statement that you looked through the side door.
I'm sorry, what?
Did you indicate that in any way, shape, or form that you looked through the side door?
That I walked through or looked?
Walked through the side door.
Yeah, I said, okay, and walked in the side door and went upstairs and we smoked a blunt.
Okay, and also in your statement, there's no indication or that you indicated that my client brought a friend, then left, and then brought another friend, and then left. It's fair to say that also, what you testified to today was not indicated in your witness statement, correct?
Hold on, give me a second to review it. It does say right after we smoked a blunt and he left and got some friends and came back. One of them said that they had a problem with me.
However, it's fair to say that you did not in your statement indicate that Mr. Gunter left again and brought someone.
No, I did not.
Now, in your statement, if you read that first question in your answer, in the statement, and you indicated that, it's very hard to read this. So you indicated when I got on Lansdowne and she, which you're indicating Manara,
Yes.
said her baby daddy would wait outside. I said, okay, and walked in the side door and went upstairs, correct?
Yes, ma'am.
We smoked a blunt and he left. Correct?
Yes, ma'am.
And who is he?
Jalen.
Okay, and got some friends and came back, and one of them said they have a problem with me. And he wants to go 30, and you said, okay, and we started fighting.
Yes, ma'am.
Okay, so you agreed to go 30?
Not right away. I didn't want to. I didn't want to fight.
And then you hit him in the face, and was that the nephew? Or the?
Yeah,
Okay, and the others started hitting me, and I hit them a couple times, and then they pushed me on the bed and grabbed pieces of wood, correct?
yeah,
And started hitting me, then they poured rice on me and hair bleach, correct?
yes, ma'am.
Okay, so in terms of your testimony today, it's fair to say that you did indicate that you were hit with a spatula wood spoon. Was that what you were referring to regarding the wood?
Yes.
Okay. And then you also indicated that your baby daddy handed me a bottle of NyQuil and told me to drink, correct?
Yes.
Okay, however, when you testified, you indicated they handed you a bottle of NyQuil.
It was.
Do you recall testifying to they?
Yes, I did.
And you recall to not identifying who specifically handed you a bottle when you testified?
Yes.
Okay. And then you also testified today that what you heard when you were asked whether you heard what they were saying, you just heard grunts, correct?
Yes.
However, in your statement, it states that you indicated that someone said they would kill you. Can you review your statement?
Yeah, that was after the fact. That was after they got done cutting my hair and pouring the hair bleach on me and hitting me.
Okay, however, you never made any mention of this when you were questioned by the prosecutor, correct? Of the statement that was made, a verbal statement when the fighting was occurring.
No, because there wasn't a
Okay.
verbal statement,
Okay.
statement when the fighting was occurring.
Okay, and then you were also asked a question in terms of, you said goodbye to Monaro before you left the home?
Yeah,
Okay, however, it's fair to say that in your report, in your statement, you indicated, I'll start at, they would kill me, so I cleaned up and I finished, they took my speaker, my phone, and my clothes and shoes, and I ran home. Correct?
yes,
So there's no mention in this four corners of the first page that you made any statements to Monaro before leaving the home?
no,
Okay, so now you had indicated that there was a wood spoon that you were hit with, and in terms of rice, what type of rice? You were hit with rice, rice was thrown on you?
it was poured on top of my head. I believe it was white rice.
Okay, so you recall when you were asked the question, you never mentioned any evidence of a gun, correct?
Right.
Okay. However, in your report, that you indicated was truthful, as you are testifying under oath, you indicated that an officer just asked you what kind of gun, did Jalen have, correct?
Mhm.
Okay, and then you had, answered black gun. Black gun.
Yes, I did.
Okay, however, it's fair to say that when you made your first report on November 26th, and then this report that you had before you on December 6th, there was no mention other than this December 6th, other than your testimony, there was no mention of a gun, correct?
Yes, ma'am.
Okay. Now, when you indicated that you, do you recall being presented a several array of photos to identify the
Yes, I do.
person that, okay. And these photos that you were provided, were they in color?
No, they were in black and white.
Okay, and you identified Mr. Gunter as a person that assaulted
Yes, ma'am.
you? Were you ever did you ever ask, or were you offered to see this lineup live, meaning observe people live standing?
No, to be honest, I did not want to. I knew who he was and I pointed him out.
Did you have any type of, did you or know of anyone that was videotaping? Did you videotape any of this recording?
No,
testified that you went to a mental health institution after this incident, correct?
Yes, ma'am.
What date did you, admit yourself into the mental institution?
No. Can't really remember, but I believe it was March 2nd to the 7th.
Okay, and this incident occurred all the way back in December 26th of this last year,
Oh, which incident?
2022? This actual incident, this report
Yes,
allegedly occurred November 26th,
Yes.
2022. But you did not admit yourself until March of 2023?
yeah, around there.
What in between that time did you do? Did you just, were you
I
working? Were you
went to
living your
school.
life normally?
I went to school
Okay.
and I was trying to focus on my grades and trying to get those up, but eventually everything just got too much for me. So I had to get away.
You had to get away from what?
People, situations, stress.
Prior to your mental institution admission, did you meet with a therapist, a psychologist?
Yes, I did.
Okay, and what date was that?
I was meeting with a psychologist while I was in there.
In where? The mental
Yes,
institution?
yes.
So that would have been about around March of 2020?
Yeah.
Okay. Now, there was also a question in terms of what you were permitted to take with you from the Lansdowne home,
Mhm.
correct? And that was your socks and underwear?
Yes, ma'am.
Okay, and now if you review your statement, it's fair to say that there was no mention in your statement of what you were permitted to take, correct?
Yeah,
Okay, and you just didn't make that statement, or were you just?
I just didn't make that statement.
Okay, so you indicated you knew Mr. Gunter, correct?
Yes, ma'am.
And you knew him through the Menara, correct?
Yes, ma'am.
Okay, and in your statement, there's also a statement a question that you were asked in terms of if you knew Jalen's Facebook and Instagram page, correct?
Mhm.
Okay, and you did answer yes.
Yeah, my sister found it.
Okay, and when was this? I mean, what
This was
expected
right
because-
after the incident. She went to social media stalking to find out who he was and who she was.
And where in the house did this assault happen?
In the upstairs bedroom.
Okay, and lastly, when you had indicated your injuries, you recall being asked what injuries you suffered, correct?
Yes, ma'am.
Okay, and give me one moment. In your statement, you were asked what all did Jaden do to you, and you answered, he punched me, hit me with a wire brush, cut my hair, poured bleach in my head and rice, pointed a gun at me, and took my phone and speaker, correct?
Yes, ma'am.
Okay, however, you today testified that you suffered bruising and a loss of left tooth, correct?
Yes.
And your pride.
Yeah.
Okay, so you changed from the statement you made from December 6th to today, taking some matters out, correct?
Yeah.
Okay, why is that?
Because I feel like those are really the only physical things that have happened.
When you made your statement on December 6th, did the officer advise you, or did you, to make, like, from your clear frame of mind, what you recall, did the officer state what you recall in totality?
Yeah.
The officer never told you to leave something out or maybe change in the future?
No.
Okay, so it's fair to say on this, December 6th statement, you were telling the truth of what you believe happened?
Yes, I was trying to remember each and every single possible detail. I might have missed a couple, to be 100% honest, because just so much was going on. But yes.
Did you seek medical attention?
Yes, I did.
And did you provide, the prosecutor medical records?
I don't think so.
How long were you in the hospital? Were you admitted into the hospital?
Yeah, I was picked up in an ambulance and I was in there for 24 hours.
What hospital?
I can't remember.
Okay, so in terms of your memory, you can't remember what hospital you were?
No.
Okay. Were you provided medications?
No, I was not.
Okay, so when you had left, were you blocked to leave? You said you ran out.
Yes,
And you ran out the front door, what part of the
the
house?
side door.
The side door?
Yeah, they let me out the side door and I ran home.
Okay, and who let you out?
I can't really remember.
Male, female?
Male.
Was Manara there the whole time this was happening?
Yes,
Okay, so you were permitted to leave or able to leave freely?
yes, I was.
Nothing further, Your Honor.
All right, is there any redirect?
No redirect, Your Honor, thank you.
All right, thank you for your testimony, sir. We are going to excuse you at this time.
Thank you for having me. Where would I?
Counselor, are these your exhibits, the statement? You handed this
Yes.
to him? All right.
Broken.
All right, is there any further witnesses?
No other witnesses from the people.
Is the defense calling witnesses today?
No witnesses.
Is there a motion?
Yes, Your Honor, people in motion for a bind over on counts 1 through 4 with the additional count 5 of torture and the count 6 of felonious assault. And would reserve argument for rebuttal.
All right, argument?
Your Honor, we would stringently object to a bind over on the initial charges along with the additional charge, 2 charges that the prosecutor is requesting be added. What we have here is clearly this court knows case law very well, very experienced, that credibility does play a role into the court, whether the court can decide whether an actual incident possibly happened and my client committed the incident. What we have here is an individual, he's 17 years old, testifies that he was going to a home, smoke weed, a trap house, that was what he identified as a crack house, which wasn't identified in his statement as what type of trap that house was. There were 2 statements, one that was made on November 26th, and then a second one that was made December 6th. 2 completely different statements. One of the statements didn't happen near or anywhere, way, shape, or form in terms of the allegations near this home of Lansdowne. It was supposedly occurred in a vehicle where he was driven around and assaulted in the vehicle, and then basically was pushed out of the vehicle, gone. And then weeks later, he comes back and makes a completely different statement that he's at a home in Lansdowne. My client is present, and he's assaulted by my client along with several other individuals. What we have here from his testimony, such as I forgot to put it in, I didn't state this because I can't remember. Oh, no, I didn't mention a gun today, but there's a testimony or a witness statement of a gun being in his witness statement. There's so much conflicting evidence here that I don't really see that this could rise to the level of credibility in terms of this complainant making a statement that would rise to the level of probable cause that my client committed this crime. If he had made the same statement, regardless if he made 2 statements, but the 2 statements were very close together in the facts, circumstances, time, date, location, yes, that would show some consistency with his statements. But given the fact that now we have a torture and the fact that, and actually the unlawful imprisonment, when my client testified on the record,
He
which was
doesn't
not,
ask for unlawful imprisonment. Have you asked for unlawful imprisonment?
That is count 4, Your Honor.
Oh, okay, that's already, because the only 2 that you're asking to add is torture and felonious assault.
Yes, Your Honor.
All right.
yes. And given the fact that the client here was with a girlfriend that was the mother of my client's child, indicated that he pretty much here today said, basically kissed my girlfriend goodbye. I'm leaving, see ya. And then walked out and ran. But regardless of how he walked out, this is how he left. An open door was open to him that he then testified on crafts that the individuals let him out and let him leave. So I don't believe this matter rises to the level of unlawful imprisonment, given the fact that he was free to leave when he clearly agreed to fight that he testified to on the record through a statement, and then through the first fight, and then added a bunch of other factors. But we have to look at really the surrounding circumstances that would rise to the level of these charges. And so I do not believe my client, based on 1, credibility, especially with the count 1, 2, 3, 4, and then 5 and 6, would rise to the level of probable cause. And 2, the fact is that he pretty much indicated and testified that I don't believe the count 4 and the torture would rise to the level, given the fact that he was free to leave. And the fact is, he testified that he just suffered a lost tooth, and he also suffered bruising. But again, in his statement, he didn't acknowledge that a lost tooth was never indicated in the statement, just bruising, etc. And in terms of the emotional connection that the prosecutor is looking to incorporate it to rise to the level of these two additional charges, plus possibly unlawful imprisonment, the complainant can't even testify to. He claims he went to the hospital, doesn't know what hospital, claims he went into the mental health facility, just gave a date that's about 3-4 months after the date, and claiming he just didn't want to be there, he didn't want to be there, and he was unhappy. I don't believe that time span would really qualify that emotional impairment came all the way from the November 26th incident, given the fact that I asked him what was he doing. He was in school, trying to get his grades up. It looked like he was living his life to the point that mental health supposedly admission, I don't believe that would rise to the level of emotional impairment leading to back to the November 26th incident. So with that, Your Honor, based on all those circumstances, I'm requesting we dismiss this matter.
All right.
Thank you, Your Honor. As it pertains to Parker's credibility, Your Honor, that first statement that he made to police officers was the same day that everything had just happened. And it was almost immediately after he was threatened and told that if you go to the police, we're going to start with your family. This is what he said, Mr. Gunter said to him. I'm gonna start with your family and I'm gonna end with you, is what he told him. So as it pertains to his first statement being incorrect, Your Honor, he was very honest about why that was. He was scared for his life. As it pertains to count 1, robbery armed, he did not testify to any gun being present today. But he did testify that Mr. Gunter had a sledgehammer, was sitting in the corner. Immediately before, they made him strip his clothing, and they took his phone and his speaker from him. As it pertains to the assault with intent to do great bodily harm less than murder, Your Honor, in this case, we had 3 men that jumped on Parker, beat him senseless, and then proceeded to pour bleach on him, all the while hitting him with wooden spoons and such. And then again, having a sledgehammer present in his hands when all of this was going on. As it pertains to the unarmed robbery, that's obviously charging the alternative. As it pertains to the unlawful imprisonment, Parker testified here that when I asked him, why didn't you just leave? He said, I couldn't. Those 2 men that were with Jalen were blocking the stairs and they were not letting me leave. So there's the unlawful imprisonment, Your Honor. He was not permitted to leave. As it pertains to the torture, I have the Michigan Criminal Jury Instruction 17.36 for torture. The prosecution must prove first that the defendant had custody or physical control over the victim, in this case, Parker Taylor. He did. He had physical control. They were not letting him leave and they were beating him. Second, the defendant exercised custody or physical control over the victim without his consent. Parker testified that he did not consent to any of this happening. In fact, he didn't even want to fight the guy, but he had to, otherwise he was going to get jumped. And he just goes ahead and gets jumped anyway. Third, at the time that the defendant had custody or physical control over the victim, he intentionally caused great bodily injury and or severe mental pain or suffering.
So you're relying on the latter.
On the severe mental suffering, yes, Your Honor. Although it wasn't immediate. Yeah, he checked into a mental institution later in March. He's a 17-year-old kid trying to live his life, but something as drastic as this happening clearly had an effect on him. He also testified on the stand, Your Honor, that when his hair was cut, when bleach was poured on him, when all these things were happening to him, he felt demoralized. He felt like his pride was shot. He didn't feel good at all, is what he testified. As to the felonious assault, Your Honor, that specifically goes to the sledgehammer being present while he's being threatened and beat. And it could also even, in the alternative, go to those wooden spoons being used to hit him constantly. So, Your Honor, I believe the people have definitely met their burden today for all 6 counts. I would ask you to bind over as such. Thank you.
All right, thank you. All right, the court's had an opportunity to hear the testimony in this matter. The witness testified the incident taking place on or about November 6, 2022 at Lansdowne Street in the city of Detroit. He found his way to that location where he alleges that his girlfriend lives there, that it's some kind of a track house. He went there to smoke marijuana. He was met at the door by the defendant, and the defendant left the location, came back with a person, left again, came back with someone else, and then at some point during the evening, he states that the defendant indicated that his nephew had a problem with him and wanted him to go 30 with that person. He stated that he did not want to do that, but was told that if he didn't, that they would all jump him. He stated that he then threw a few punches, and at that point, he was jumped on by all of the individuals anyway. He stated that during this time point that he was hit, kicked, he was hit with objects that were laying around the room, thrown into a wall where he hit his head. He then stated that the defendant and others poured barbecue sauce on him, bleach, rice, and then cut his hair. He stated his hair was shoulder length and that he was basically scalped. He stated that the actions of the defendant and others caused him to feel demoralized, that he felt that his identity was taken as a result of this experience. They then made him down an entire bottle, made him drink an entire bottle of NyQuil, then made him clean up the area where they had poured the barbecue sauce and the rice and the bleach on him. And while he was doing that, he states that a person was holding a sledgehammer. Then they made him strip down to his underwear. And then while that person was holding that sledgehammer, he states that his phone and speaker was taken from his person. He was allowed to leave at that point. He indicated that he attempted to leave earlier, but the stairwell was blocked by the other two individuals, I believe is what he stated, or someone was blocking the stairwell where he could not leave. And before he was allowed to leave, he was threatened that if the police were involved, that the defendant would start with his family and so forth. And then he left and ran home. He stated that as a result of this incident that he lost his left tooth, he had some bruising, that his pride was affected, and that he takes medication now for PTSD as well as depression. So as it relates to the armed robbery, the court finds that the people have in fact met their burden based on the testimony of the witness. The fact that there was a weapon that was present when these items were taken from him that would have put him in fear of the larceny. The very fact that it is present and his state of mind and what he was feeling, that this would have been considered force or violence used against him in taking of those items, that he, was put in fear while he was, these items were taken from him. So that satisfies count one. This says handgun. And so I don't know where that's coming from, but he did not give testimony about a handgun. And that's what your count one says. So I don't know if you're asking to amend the factual part of count one.
Yes, Your Honor.
That would change that to the sledgehammer. But I know there might have been something in a statement but his testimony today didn't mention anything about a handgun.
Yes, Your Honor, I would agree, and I would ask him, I would motion to amend that factual bit just from the handgun to a sledgehammer, which is what it should have said.
And the court will take note of that. And then the assault with intent to be grave, bodily harmless and murder, based on the encounter that he stated he endured, and the fact that he was jumped on by 3 individuals, that this went on for a period of time, that he was slammed into a wall, that he lost a tooth. I mean, all of what happened to him, I think, would satisfy the assault with intent to do great bodily harm. And he stated that he was bruised, he lost his tooth, his hair was, cut, and, scissors were involved. I mean, it's a stretch, but I think the people marginally have satisfied this particular account, particularly when you listen to his testimony and he talks about the time period that he was allegedly beaten by these three individuals. It wasn't just a fight where, 30 seconds you go in for a fight. It wasn't anything like that. This was something that he has described that endured for a period of time. And so he was taking those blows, to his body. And so, yes, the count 2 would be satisfied by that testimony. And then count 3 in the alternative of count 1, that has been satisfied. Unlawful imprisonment, he indicated that he attempted to leave. He did not want to be there. He wanted to leave, he was not able to leave, and so that count is satisfied as well. Now, when we get to, and the felonious assault also, that would be satisfied, but the fact that there was a person there which had the sledgehammer, and that he was put in fear of being hit with that, had he not done what he was being asked to do. So that's satisfied as well. Now we get to the torture. And I'm looking at that, counsel, and I understand the circumstances of what this man allegedly endured on that day. The statute says a person who, with the intent to cause cruel or extreme physical or mental pain and suffering, inflicts great bodily injury or severe mental pain or suffering upon another person within his or her custody or physical control, commits torture. I think marginally the people have established that there are facts that create a question of fact for the trier of fact on this count. Based on the testimony of the witness and what he endured for the period of time that he endured, the humiliating acts of what he was required to do. Torture does not necessarily have to mean physical pain, but the statute allows for a component of mental pain. And based on his testimony, he indicated the effect that these acts had on him from a mental perspective, and what that he is now treating for the effects of what happened to him on this particular day, having his hair cut off and having food items poured over him, bleach on him, not knowing what was going to happen next. He stated that it's caused him to feel demoralized, and that his he felt his ID had been stripped away from him. I mean, these are all going to be questions of fact for the trier of fact. While there may have been conflicting testimony regarding the statements, he did indicate that he was in fear when he made the statement based on what was said to him, that that they would go after his family. So whether or not the defendant was untruthful at one point in time and truthful at another point in time, again, that is for the fact finders to determine. So this court finds that the people have in fact met their burden. This court will find that there is probable cause that the crime was committed in the city of Detroit, and that the defendant has been charged appropriately. This matter will move forward to the Wayne County Circuit Court for trial. Arraignment on the information is, we were given now, April the 24th. For some reason, we were given out the 25th today. Is it April 25th? Yes.
Yes.
April 25th, 2023 at 9 a.m. is the exam date. All right, that concludes this hearing. If there's no objection, the court will move on.
Mr. Gunter had a hearing on a second case yesterday, and the AOI was scheduled for the 24th. Is there a way you can?
You would have to, I would defer to Madam Clerk on that. It's my understanding that they don't change these AOI dates, but if there's a way that it can be changed, do you know?
No, I have to do it across the street.
Yeah, so across the street, you
Just let them know.
can, yeah, let 'em-
And Mr. Gunter would like me to address bond on his behalf,
All right, quickly, counsel.
very quickly. Your Honor, Mr. Gunter is 21 years old, and he has no prior criminal convictions. He's been in jail since the date that I first spoke with him prior to that date in January 2023. I did, given the fact that I have been in communications with his mother, and he does have some mental health issues that he was currently seeing a therapist that would like to maintain on that process. His mother did schedule an appointment for him to see the therapist, I believe, next week. So, Your Honor, given the fact that we already know what the purpose of a tether is and house arrest, and tethers are very sensitive. If an individual, there wouldn't be a tether in place if it wasn't effective or for a purpose. So we're asking that you allow him, based on his age, his prior history, you allow him to be released on at the minimum, well, at the lowest, 100,000 cash and surety bond, but even lower, a personal bond. But my client indicated his mother could post $100,000 cash and surety. I'm asking you add house arrest and tether, given the fact that he is planning to resume his online school.
All right, thank you, counsel.
Your Honor, the people would object. May I ask Your Honor or Madam Clerk what the current bond is?
150,000 cash surety.
Yeah, Your Honor, I would definitely object to any ruling. I believe 150 cash is still low, especially given the testimony that we heard today. As it relates to flight risk, no question, there's nothing to indicate that he is. But as it pertains to being a danger to the community, Your Honor, I think what we heard today absolutely shows that Mr. Gunter is a danger to the community. And I would object to any reduction in bond. In fact, I would ask the court to even raise the bond.
All right, thank you. All right, the court making a determination regarding the bond. There are a number of factors that the court has to consider. The two of the most important ones for the court to consider is the safety of the community based on a number of factors, the criminal history, the nature of the offenses, also whether or not the defendant is deemed to be a flight risk. The court has now had an opportunity to hear the testimony in this matter, and based on that testimony, this court finds that there must be a sufficient cash bond to reflect that the defendant is in fact deemed to be a threat to the community based on the information that this court has received in this hearing. The court also understands that the defendant is presumed innocent until proven guilty. However, the court has to take into consideration the allegations against the defendant. I appreciate the fact that the defendant does not have a prior record or any history of habeas, but the facts that were elicited from this hearing today suggest to this court that the defendant is in fact a danger to the community and that the bond is appropriate to ensure the safety of the community, and this bond will continue as is and may be addressed with the circuit court judge at the AOI. All right, thank you.
Thank you, Judge.
All right, next matter. Oh. I have to take a break.
Tyrone, this is Jim. I mean, if you were downstairs.
You just have one more?
Yes, it's the last one, Judge.
All right, thank you.
Yeah, he's, mine's down right now.
Everybody else?
Yeah. We really appreciate it.
All right, counsel, are you ready?
Yes.
All right, which case was this? which case, what time was this scheduled for? I'm so
11:15,
sorry.
Mr. Mandy.
How much? What time?
11:15.
I'm so sorry.
It's okay.
I apologize. I didn't finish my docket until after 12, so.
You guys are a little short staffed, so.
Yes, we are. All right, you did a waiver on that other one. Okay.
Correct.
Yes, Judge.
What happened to, the Adam matter,
That,
11:30?
Adam was a waiver.
Did I do that one?
No, I think Judge King did that one.
Okay.
No, you did it, Your Honor.
Oh, she did?
You did it via Zoom.
Oh, that's right.
Your
That's
case,
fine.
Adams, yeah, okay.
Ready?
Yep.
Calling case number 2356006, the people of the state of Michigan versus Noah Mandita. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
Good morning, Judge. Alex Ring on behalf of the people, P number P86590.
Good morning, Your Honor. Good afternoon, Your Honor. Vanessa Hamilton, P82107, on behalf of Mr. Mendieta, joins us in the courtroom to my right.
All right, state your name, please.
Good afternoon, Your Honor.
All right, you may have a seat, sir. Counsel, you may call your first witness.
People call Officer Perry.
Your name, please. You can step right up there, please. Deshaun, here, spell Deshaun for me.
DESHAW. Very comfortable.
All right, and raise your hand. And do you affirm the testimony you give this court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may be seated.
Good afternoon, Officer Perry. Please state your name for the record again.
Deshaun Perry,
What is your job?
police officer,
Where do you work at?
Detroit Police Department,
And how long have you worked there for?
a little over 3 years.
Were you working in that role on the date of March 16, 2023,
Yes,
at the location of Braille and Grand River, Detroit, Michigan,
yes,
Detroit County of Wayne?
yes.
What did you observe that day?
In the area of Grand River and Southfield, it's a green light gas station.
When you were at that location, the Fremont gas station, what happened?
I observed several individuals, exit, black SUV, enter another vehicle and completely leave the gas station, leaving the car, abandoned at the gas station.
So when you saw them in vehicle 1, we'll say, get into vehicle 2, did you do anything when you saw them in vehicle 1, or what did you do?
Once I observed that they left the location completely and nobody was inside the gas station that was previously in the vehicle number 1, I ran the license plate for the vehicle. I got negative results. I ran at the end of that vehicle and discovered that it was reported stolen by West Atlanta Police Department.
When you saw that was reported stolen, what did you do next?
I advised my partner, Officer Flannel, and we went to see if we could find the vehicle that the occupants of vehicle 1 had got into. We observed that vehicle going west on Grand River and then south on Brill.
So when you were able to get to vehicle 2, what did you do next?
Initiate a traffic stop,
When you initiated that traffic stop, what did you do?
approach the vehicle. Once we approached the vehicle, I observed the front seat passenger of vehicle number 1 and the rear seat, rear passenger side of vehicle number 2.
So when you
Saw them what?
I just observed them in the vehicle number 2.
so you viewed the people from vehicle 1 got into vehicle 2.
Correct. I confirmed that that was the same vehicle I saw them get into.
Okay, thank you.
When you did the stop and then you pulled them over, what did you do next?
Confirmed it was them. Once we confirmed it was them, I engaged the front seat passenger, like I said before.
So you see the front seat passenger in the courtroom today?
Yes, I do.
Can you identify them by a piece of clothing today?
So, I believe he's wearing a nice blue or black suit, sitting behind the defense counsel.
Let the record reflect that the witnesses identified the defendant.
All right, so noted for the record.
So when you approached the front seat passenger, what did you do next?
He was in the rear seat.
Rear seat.
I engaged him. I asked him, first of all, was there any, because I wasn't detained him for the vehicle to complete my investigations for the stolen vehicle. I asked him, was he armed? Was he had any weapons inside the vehicle? He stated no.
What did you do next after you asked him that question?
Said it one more time.
What did you do next after you asked him that question?
I advised my partner, Officer Fleming, who was going to detain him from the vehicle. I observed that once my partner, Officer Fleming, detained the passenger on the other side of the vehicle, the defendant got extremely nervous. You can tell, hand in his face, he just was visibly nervous.
Then what happened next?
I asked him again, was he armed? He stated no. I opened the door. I told him to put his hands up. I put one handcuff on him to detain him from the vehicle. And as I began to detain him from the vehicle, he advised that he did have a firearm in his hip.
What did you do when you, with the firearm in his hip, what did you do next?
I performed the frisk of his waistband, discovered that he was concealing a brown Ruger, I believe EC9S, loaded with an extended magazine. I recovered it from his waistband, secured it on my person.
Did you, so it was on this person, did you run any check to be able to see that the defendant was able to carry that weapon?
Yeah, let me back up. Before I recovered the weapon, I asked, was he a CPL holder? He said he was not. Detained, secured the weapon on my person, secured him in the backseat of the scout car. I did run him in lean to see if he was a CPL holder. He said, per lean, he was not a CPL holder.
No further questions.
All right, Franz, please.
And there's Officer Perry. So you stated that you were initially at a gas station and you observed some individuals get out of a car.
Correct.
And you said that at that point you had determined they abandoned the vehicle?
Yes, we patrolled the parking lot to make sure that nobody, because somebody could have still been inside the gas station that was inside the vehicle. Once we determined that nobody was coming out to get the car, I ran the plate to see what was going on with the car.
Okay. And how long did you observe the car there without anyone in it?
Maybe a minute or two.
A minute or two. And have you done this with other cars in the past?
Actually, I'm not sure if I observed anybody leave a vehicle at the gas station completely. I'm not sure.
Okay. And so is that your typical, say you encountered an abandoned vehicle that was had been on the street for a number of days, what is the process that you would take with that abandoned vehicle?
Run the plate, make sure it's not stolen. See where the vehicle is registered to. If it's not registered to where it's parked at, it's probably gonna get towed.
And if the vehicle does come back stolen, at that point, what happens with the vehicle?
Are you sounding like a hypothetical? Like what?
Yeah. If an abandoned vehicle is determined to be stolen, what are the next steps?
Same thing, I'm gonna impound it, notify the TCRU to take it out of the system that's, so that it can show that's been recovered.
Okay. And so in this case, you decided to go try to find the other car that some individuals had gotten into?
Definitely, I observed individuals exit that vehicle and enter another vehicle. So at that time, I'm gonna do my best to investigate those occupants for the new vehicle.
Okay, and how, you say you waited about a minute or two and then you went to go find this vehicle, or how long was it between when the vehicle left the gas station and when you went to go find it?
I can't tell you how, once I determined that the vehicle was stolen, I immediately went to go to find a canvas for the other vehicle. So I'm not sure exactly on the time limit, but once we determined that it was stolen, we went to go canvas for the other vehicle.
Okay, and so how did you know that the people weren't going to come back to the vehicle within the next 5 minutes?
Honestly, after I determined that it was stolen, I didn't care whether they was coming back or not, I was going to get them.
Okay, so you were just running the plate on the vehicle because it was parked and no one was in the gas station?
not just because no one was in it, it appeared that all the occupants that was in the vehicle got into another vehicle and left the location.
Okay, and what crime, did
So-
you suspect was occurring at that point?
It's no, I didn't expect no crime to be occurred, I just wanted to see what's going on with the plate, because if you abandon a vehicle, it's weird, so I just ran the plate off.
And so do you normally run license plates of empty vehicles at gas stations?
I do sometimes, yes.
Sometimes, okay. And so is there a certain amount of time that you wait to see before someone comes back to see if maybe they were in the gas station or around the corner?
Do I usually wait? No. Honestly, I've recovered several stolen vehicles just by running random license plates inside of my location.
Okay. And so then you stated that you eventually went and found the vehicle that they got in. Was it in motion or where was it?
It was driving westbound on River,
Okay. How long did it take you to locate that vehicle?
maybe a minute and a half, maybe. It wasn't a straight line from where I last seen them, so it wasn't hard to locate.
And so then you said that you conducted a traffic stop right away.
Yes.
Did you see any traffic infractions occur?
Yeah, I ran the license plate. I believe it came back with no insurance. I believe. I'm not sure.
And so then you said that there were, how many people were in this vehicle when you pulled it over?
4, including the infant child.
Okay. And you stated that you saw Mr. Mendieta, my client, in that car. Where exactly was he in the car?
Rear seat passenger, so rear seat behind the passenger.
Okay, and who was driving that vehicle?
A male, he's in my report, I'm not sure his name.
Okay. And were any citations issued for the driver of that vehicle?
Yes, I believe he was issued ticket with no insurance.
But he was able to drive away from the scene?
Yes.
And did you speak to the driver at all?
Maybe briefly.
And so you stated that you asked the passengers in the vehicle, or you asked my client specifically if he had a weapon?
Yeah, any weapons, yes.
Okay, and did you ask any other vehicles, any other passengers in the vehicle? If they had weapons?
I'm not sure. I know I asked the rear seat passenger, Mr. Mendieta. I asked him first because I knew that I was going to be placing him in handcuffs.
Okay.
So by that point, I just wanted to make sure that he was armed.
Okay, so why did, you said you knew you were going to place him in handcuffs?
Yes.
And for what reason did you intend to put him in handcuffs?
I still hadn't completed my investigation from the stolen vehicle. Like by me observing him exit the front seat of the stolen vehicle and get into the rear seat of the new vehicle, he's gonna be detained until we've, completed our investigation.
And you said that transfer from one vehicle to the other, that occurred at a green light?
Grand River and Southwood.
Okay, and so does that mean that there will be video footage of that occurring?
It should be.
Okay, and do you know if you secured that at all, in the course of your investigation?
I don't know.
And so you say that he said he had no weapons. What did you do then? You say that you asked him to get out of the car?
Yes, so I asked him to approach the vehicle. As soon as the window was rolled down, I observed it was him, confirmed it was him. I asked him, was he armed? Did he have any weapons? He stated no. I asked one more time before I opened the door to place him in handcuffs. He said no again. After I placed him the first handcuff on, he stated that he was armed, that it was in his hip.
And so you were, at that point, you were detaining him for officer safety?
I hadn't completed my investigation yet for the stolen vehicle. So until I completed my investigation for that, he was going to be detained.
Oh. And did you ask him any questions about doing an investigation into that the stolen vehicle? Did you ask him about that stolen vehicle?
I'm not sure. I know the driver of the stolen vehicle was sitting in the backseat along with Mr. Mendieta, and he was observed based in the driver's seat of the vehicle. So at that point, he was in possession of the vehicle, and at that time, he was placed under arrest for the possession of the stolen vehicle.
Okay. And so do you know, was he ever charged with that?
He was charged. We arrested him, both he and Mr. Mendieta, was both placed under arrest for 2 separate charges. Mr. Mendieta was placed under arrest for the CCW, and the other male was placed under arrest for PSV.
Okay, and do you know
I'm
the
sorry,
status
I'm
of
sorry,
that?
placed under arrest for what?
Possession of stolen motor vehicle,
You used an acronym, what was it?
PSMV. PSMV.
Okay, thank you.
Okay, and, Mr. Mendieta is not charged with any sort of, charges associated with that stolen vehicle?
Oh, no, he was not.
No further questions, Your
All right, thank you. Any redirect?
No further questions, the people
All
are.
right, thank you. Are the people calling any additional witnesses?
You do not.
All right, is defense calling witnesses at this hearing today?
No, Your Honor.
Is there a motion?
The people motion to bound over on count one and reserve the vote.
Your Honor, obviously, we would object to bind over, on that matter. I believe that the search, of my client was not proper. They were investigating a vehicle that, they thought maybe some individuals had gone from one vehicle to the other. My client, I just think that's, a pretty vague, it's a little vague for, an investigatory stop of that nature. But additionally, my client was a passenger in the vehicle. There were no questions asked of my client about, the stolen vehicle or anything of that nature. He was simply taken out of the car and put in handcuffs. That's against his constitutional right as a citizen, someone that was just riding in a vehicle as a passenger. And for that reason, I believe that, the prosecution has not met their burden.
All right, argue.
Officer Perry determined that the vehicle was stolen per lien, initiated a stop from vehicle one, initiated stopped when he got into vehicle two, witnessed the defendant from vehicle one get into vehicle two, detained the defendant, recovered the gun off of the defendant's person, there was no CPL. The people motion bound over on count one.
All right, so let me see if I can piece this all together. I certainly can't based on what you just said. All right, the court has heard the testimony of the officer, the incident taking place on or about March 16, 2023 in the city of Detroit at or near Braille, Grand River. The officer testified that they came to the location where the gas station was, that they do patrol at this particular parking lot. They observed several individuals, one being the defendant, leave one vehicle and then enter another vehicle, leaving behind a vehicle at the gas station. They did a run on the VIN, and it turned out that that vehicle that he observed the defendant exiting was a stolen vehicle. He stated that they then went to look for that vehicle, that they observed the defendant and another person entering, found that vehicle at a location on Grand River, observed that the front seat passenger and the rear passenger were the same two people that got into the vehicle and left the stolen vehicle. The officer approached the defendant, who was the front seat passenger, in order to investigate. He stated that he knew that he would be detaining the defendant for further investigation regarding the stolen vehicle. Approached the defendant, asked if he was armed. The defendant said no. He was removing the defendant from the vehicle to place in handcuffs while he would when he planned to further investigate, and that the defendant then indicated that he was armed with a weapon. That weapon was found in his waistband. There was no CPL. The defendant admitted he did not have a CPL. This court finds, based on the testimony, that the search, the court will not make a finding that that search was improper. This court will find that there is sufficient evidence to move this matter further for trial. This court finds there is probable cause to believe a crime was committed in the city of Detroit, probable cause to believe that the defendant has been charged appropriately, and the matter is bound over. Arraignment on the information is scheduled for May the 2nd That'll be at 9 o'clock. If there's no objection, that will continue the bond. The court will continue the
No
bond.
objection, Your Honor.
All right,
Yeah.
all right, that concludes
Thank
this
you.
docket, I believe. Yes. All right, can you log us